Well, good morning, everyone. I hope you guys are having a wonderful start to fall. Happy second day of fall, I guess. And I am this year's chair of the Nonprofit Symposium, and I will be leading these meetings until then, until the climax of our 2026 symposium that's coming up next year. I wanted to take a second and thank our previous chair, Omid Mohebi. He has done such an incredible job, and I know I have very big shoes to fill, but I am excited to try and come close to what he's put together over the last year. He's done phenomenal. And if we were live, I'd love for you to clap for him so we can virtually clap for him. So thank you, Omid.
Thank you. Thank you.
A couple of things. First, I want to tell you a little bit about, oh, those are nice. So I want to tell you a little bit about me. I'm Maria Georges, and I am the managing director of our nonprofit team at First National Bank. I'm thrilled to be this year's chair, and I'm here to just give a brief introduction to some of the housekeeping that we need to be aware of, and that is please keep yourself on mute as we can, so that our speaker has the opportunity to present without any background noise. There will be polling questions to make sure that you're paying attention, so please look out for the polling questions. And if you have any questions for Jeff, we want you to put them in the chat box, and then Carrie will be monitoring those and will be interrupting Jeff, or not interrupting him, but basically will present him with questions throughout the program. So feel free to ask all your questions. Last thing is we will have a symposium planning meeting directly after this. So I hope you all can stay on and help us with the symposium planning meeting, which happens right after this meeting. And now I'd like to introduce Tina, who is from First Citizens Bank, not First National. Remember, they're two different ones. First Citizens Bank. She is going to introduce our sponsor for the nonprofit section this year. And she's going to tell us a little bit about First Citizens Bank before and introduce Jeff. So thank you. And Tina, I'll give it back to you.
Hey. Well, good morning and thank you. Thank you, Maria, for the introduction. I am Tina Townsend. I am a commercial deposit officer for First Citizens Bank. First Citizens Bank is the largest community family-run bank in the country. Our title says it all, First Citizens, we put our clients first. So real happy to be here this morning and very happy to introduce Jeff. Jeff Tannenbaum is widely regarded as one of the nation's leading nonprofit attorneys and also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized six-attorney, Washington, D.C. based Tannenbaum Law Group, Jeff counsels senior management and boards of directors of his clients and the broad array of legal and sensitive business and governance issues affecting charities, trade and professional associations, foundations, conservation groups, international NGOs, arts and cultural institutions, think tanks, educational institutions, and other nonprofit organizations. He is widely regarded as an innovative, highly responsive attorney and with great judgment who provides practical, understandable advice extending to virtually every nonprofit, legal issues, best practices. Jeff also regularly represents clients before Congress, federal and state regulatory agencies, and in connection with governmental and internal investigations, enforcement actions, litigations, and dealing with the media. So with that, Jeff, the floor is yours.
Thank you.
Welcome.
Good morning, everyone. Glad to be here with you guys again. So we have a lot to talk about today. There's a lot I can talk about it, and as I have often done in my time with the Greater Washington Society of CPAs nonprofit section. I want this to be driven by what you guys want to hear about. So I need you to start flooding the chat box with questions and issues that you want me to opine on and talk about today. Um, as you heard and as you know, I've spent my entire 30-year career in DC in private practice as an attorney representing nonprofit organizations. I deal with the broad array of all of the different legal issues that nonprofits deal with. And in addition to all the usual day in and day out issues that I've been working on for decades, the past 8.5 months or so have certainly thrown some new wrinkles our way in the nonprofit community, as you all know. Um, the actions of the current administration, as well as some of the kind of fallout repercussions and other actions that we're seeing in the courts and in the states and elsewhere, have certainly had a tremendous impact on nonprofit organizations, some more than others, to be sure. Um, but these are challenging times for nonprofit organizations. There's a lot of fear and apprehension. Again, for some more than others, depending on the type of nonprofit you are, depending on whether you receive federal funding, depending on the nature of your causes and your issues and your mission or your industry or the profession that you represent. So I want to be able to talk through all of that today with you, kind of maybe try to cut through some of the risks that are real, some of the risks that might be overblown, and most importantly, give you some good ideas, guidance, practical tips, suggestions for how to mitigate risk in your own organizations or your clients' organizations. So while you guys are kind of gathering your thoughts and your questions, and again, pose those in the chat, and then Carrie will kind of pose those to me as we go along. Let me kind of start off by setting the stage of what are perhaps some of the biggest current threats and risks emanating from the current Trump administration facing the nonprofit community. So in my view, kind of the three biggest risks that nonprofit organizations face, emanating from the current administration, as well as related things, and I'll talk about what I mean by that, because it's not just the administration. The three biggest risks come from, number one, federal funding. If you receive federal funds, if you have lost federal grants or cooperative agreements, as many nonprofits have, if you're worried about losing your federal funding, if you're trying to seek federal funding, certainly that's a big risk from a financial perspective. It's also a big risk from a legal perspective because Title VI of the Federal Civil Rights Act of 1964 makes it illegal to use federal funds in any manner that discriminates on the basis of race, color, or national origin. And as we all know well now, especially after the June 2023 U.S. Supreme Court decision involving college admissions, that also means reverse discrimination. And that's really been the focus of this administration when it comes to Title VI enforcement. So if you receive any federal funds, you have to be extremely careful in how you utilize those so you're not engaging in a Title VI violation. And there's been a lot of enforcement and a lot of investigations by the administration from the Department of Justice, from offices of civil rights of a wide array of federal agencies, as well as elsewhere, including private litigation in this area. The second biggest risk area, and it's one that theoretically applies to every or virtually every nonprofit organization, is in the employment space. And again, as we saw a little over 2 years ago when the U.S. Supreme Court issued its college admissions decision involving Harvard and UNC, University of North Carolina, that made it illegal to engage in any sort of racial or other preferences in connection with college admissions. The court adopted a kind of reverse discrimination line of reasoning, which has now been very much applied by private plaintiffs in litigation, by the U.S. Department of Labor, by the EEOC, Equal Opportunity Employment Commission, and by state departments of labor in certain states in bringing actions for reverse discrimination in employment practices, in hiring and promotion, anything relating to employment. So that is a big risk area because virtually every nonprofit has employees and has employment policies, has employment practices, and it's really important that you carefully scrutinize all your employment policies and employment practices to make sure that you're not engaging in any form of discrimination, including reverse discrimination. And like I said, with the wide array of potential enforcement there, including from private plaintiffs, it's a very significant risk area. And importantly, there was a U.S. Supreme Court decision this term in June. It was actually, believe it or not, a unanimous decision by the U.S. Supreme Court. Used to be that if you were bringing a reverse discrimination employment claim as a private plaintiff and you were a member of a majority class, not a minority class, that you had a much higher bar that you needed to be able to overcome a kind of a hurdle, jurisdictional hurdle, in order for the case to be able to move forward. The U.S. Supreme Court unanimously agreed that's wrong. That should not be the case. Regardless if you're a member of a majority class or a minority class, if you're bringing a discrimination claim, whether it's classic discrimination or reverse discrimination, it doesn't matter. There should be no higher bar for you to bring. And so that has now been eliminated, and that has really opened kind of the floodgates to even more employment litigation in the kind of using that reverse discrimination line. A third big area of legal risk these days comes from, believe it or not, the original Civil Rights Act in our country, Civil Rights Act of 1866, which was enacted at the end of the Civil War to protect the rights of the then freed slaves, to enable them to be able to earn a living, and it prohibits discrimination in contracting on the basis of race. And for hundreds of years, that statute, it's called Section 1981 of that Civil Rights Act of 1866, again, makes it illegal to discriminate in contracting on the basis of race, was used and applied as you might have expected it to be applied, and it was intended to be applied. But after the U.S. Supreme Court's decision 2 years ago involving college admissions that adopted that reverse discrimination line of thinking, the same individual, Ed Blum, who brought those Supreme Court cases involving Harvard and UNC, started bringing lawsuits against nonprofits and others that were offering scholarships, grants, and fellowships, all of which involve contracts that had eligibility criteria that were limited to only certain individuals based on race and other protected characteristics. His conservative nonprofit that he formed, the American Alliance for Equal Rights, brought lawsuits against a number of different nonprofit organizations, including the Fearless Fund, including the American Bar Association, including the he filed complaints about the Bill and Melinda Gates Foundation for their signature scholarship program. Another conservative nonprofit that's popped up recently called Do No Harm has brought lawsuits against the American Chemical Society, triggered an investigation against a nonprofit called Academy Health, and others, pretty much all alleging that their scholarship and grant programs, all of which involve contracts, discriminate against people who do not have certain protected characteristics, including race. And for the most part, this litigation has all been very successful from the plaintiff's perspective. There was a favorable 11th Circuit Federal Court of Appeals decision involving Fearless Fund, which held that the plaintiffs were very likely to succeed on the merits of the case. And in virtually every other of these cases, the defendants have either abandoned their programs or changed their criteria to eliminate those limited eligibility criteria that included race. And so if your nonprofit organizations have scholarships or grants or fellowships that have eligibility criteria that are limited based on race and other protected characteristics, which many nonprofits still have, in my mind, they're illegal. They are blatantly illegal. They create risk for you. And no matter how large or small your organization is, groups like Do No Harm and American Alliance for Equal Rights are not afraid to bring litigation. They're not afraid to file complaints with federal agencies, offices of civil rights, and others. And you really need to find ways to either scrap the programs if you're no longer interested in them, or what more nonprofits have done, change your eligibility criteria to base it on other eligibility criteria other than race. The most common thing that we've seen is what the Bill and Melinda Gates did, which was to eliminate, they have a signature college scholarship program, the Gates Foundation, and now eligibility is limited just based on income. Basically, if you're eligible for a Pell Grant, then you're eligible for their scholarships. And it's also another thing to keep in mind is that um, the Pam Bondi, the U.S. Attorney General, at the end of July issued a memo, which basically said, in a nutshell, we're going to really enforce reverse discrimination in every form. And we're not just going to look at, for instance, explicit race-based eligibility criteria, but we're going to look at proxies for race. So basically, don't try to use other things that are a proxy for race, because we're going to go after and attack that as well. And it was a directive to other federal agencies as well. And so it's really kind of increased the risk profile for any nonprofit that has scholarships, grants, or fellowships that have any race restricted eligibility criteria. I think I saw a bunch of questions in the chat.
Yep.
Carrie, you want to pose some of those to me? Because I think they're on this topic.
Yeah, I'm going to do those first, then we'll get to the new topics. So specifically, I think you already answered this, but are programs that offer scholarships or other opportunities based on financial need currently deemed discriminatory? Sounds like no, but
Mm,
is that a
Well,
proxy?
I mean, just because the Gates Foundation changed their eligibility criteria that way doesn't mean that it's necessarily lawful. And for we really don't know yet until we see how some of these things might play out in court. Um, the Bondi memo, some attorneys believe that, some of the positions she took are actually not supported in the law. One thing that Justice Roberts said in his majority opinion in the college admissions decisions was that while it's both unconstitutional and illegal for colleges to give any preferences based on race in the college admissions process, that if a student applicant wrote an essay explaining how they had overcome racial discrimination in the past to get to where they are now and overcame those hardships and made them the person they are today, that would not be illegal or unconstitutional. Pan Bondi seems to disagree with that, and saying like things like that are a proxy for race. She said, if you're recruiting practices, for instance, and you're only doing recruiting from historically black colleges and universities, that's a proxy for race. I don't know that the courts are necessarily going to adopt that position. We'll have to see how things play out. Bondi took a pretty aggressive position there. I think it's probably pretty safe that if your eligibility criteria are just based on financial need, that it's hard to argue that that's a proxy for race, and I think that's probably unsafe ground.
Okay. And what about if the eligibility criteria, those scholarships are funded by a restricted fund or dedicated funding?
Yeah, we've been dealing with this issue a lot. So, and this happens sometimes where legal risk and the law kind of bumps right up against donor restrictions. Um, so for instance, a lot of nonprofits have, endowment funds, restricted funds that a donor, grantor, whatever, had given in the past, to provide scholarships to minority candidates, to, say in a professional association where there's a low number of minority candidates in the profession, which we see in a lot of professions. There historically have been scholarship programs and other grant programs and things designed to increase the number of minorities in the ranks of that profession. And so if you have a, donor restricted fund that's limited for those purposes, that is a donor restriction that you have to deal with, but it doesn't necessarily make it lawful if it potentially violates Section 1981 of the original Civil Rights Act. Now, there are provisions under UPMIFA, the Uniform Prudent Management of Institutional Funds Act, a model law that's been adopted by every state in DC, which provide mechanisms for altering donor imposed restrictions in certain circumstances, including where they violate the law. But we don't have time in this session to get into the nuances of MIFA and how you do that. But the short answer is that if the donor, not the donor's family, but if the donor is still around, still alive, still reachable, the easiest solution is to go back to the donor, explain the situation, and ask them for permission to modify the eligibility criteria in a way that will not violate the law. There also are other mechanisms where you can go to the applicable state attorney general for your state of incorporation and try to seek consent if the donor is no longer reachable, things like that.
Okay, great, thank you. Okay, I don't have other questions right now about that, but I did have one I saw popped up about the Johnson Amendment. Can you talk about that a little bit?
Yeah, so the Johnson Amendment essentially makes it illegal for 501c3 organizations, which also include religious organizations, to engage in political campaign activities, supporting or opposing candidates for public office, supporting political parties, things like that. Um, there's been um, there's been a move both by the administration and I think we're going to see some action in the courts and potentially on Capitol Hill to either eliminate or weaken the Johnson Amendment. There was also a ruling fairly recently by the IRS, which held that, or maybe it was a court, I take it back, I think it was a court decision, which held that if, for instance, a preacher at a church is, speaking from the pulpit and, endorsing candidates, that's not going to be attributed to the church itself in terms of the 501c3 organization and potentially risking its tax exempt status. That's somehow protected speech that should not be attributed to the organization. That's a lot of what's going on. It primarily relates to religious organizations, although certainly if Congress decided to repeal the Johnson Amendment, it could have an impact on every 501c3 organization and its ability to engage in political campaign activity. And remember that political campaign activity is separate from lobbying activity. So 501c3s are prohibited from engaging in any political campaign activity, but they are allowed to engage in lobbying activity up to certain limits. There's two different alternative sets of lobbying rules, lobbying tax rules for 501c3 organizations, depending on whether you make the 501h election. But lobbying, which if you make the 501h election means legislative lobbying, is permitted, but up to certain limits. And just always be sure to distinguish that from political campaign activity. And of course, 501c4s and 501c6s are not, they have no limits on lobbying. They can engage in unlimited lobbying as long as it's mission related. C6 organizations are, however, subject to the lobbying tax law, which limits the business tax deductibility of membership dues to the extent that the association engages in lobbying activity.
Great, thank you. Well, since you're talking a little bit about lobbying, I'm just kind of curious if you anticipate there to be some changes to restrictions on lobbying for nonprofits coming soon too.
Um, my legal response is, who the hell knows? Predicting what's going to happen with Congress these days is, I'm not a betting guy, but if I was, I wouldn't be betting on that. I don't know. There's been talk about a second tax bill. I think that's probably an uphill fight. A second kind of big tax bill, and that's typically where that stuff would come from because it's all primarily tax code based. I haven't really heard a lot of serious talk about that. So I don't think that that's likely. But actually, as we're on the topic, some people would say, and of course the president and vice president have been fanning the flames of this issue very even as within the last week. And some people would say the fourth biggest area of risk for nonprofits these days are threats to tax exempt status. And certainly when you have the president and vice president calling out certain kind of left-leaning nonprofits like the Ford Foundation and Open Societies, saying that their tax exempt status should be revoked because they're inciting violence. Um, it certainly gets people's attention. There's also been some talk. There is a provision, a lot of people don't know about it. I believe it was enacted after 9/11. I'm not 100% positive about that. But Section 501p, like in Paul, of the tax code, provides that the president, through an executive order, can automatically and instantly revoke the tax exempt status of any organization that is deemed to be a terrorist organization or that is supporting terrorism. Um, Now, and those terms are defined by reference to two federal statutes, which define it as foreign terrorism. Okay, that's an important distinction that hasn't been really reported on in the press. Foreign terrorism. And if the president does this, there's the statute says there's no right to appeal it, which is really unusual and surprising, but it is what it is. There's no right. You can't go to court and challenge it. Um, and so there has been some talk by some folks in the administration about the president using that provision 501p, to revoke the tax exempt status of organizations that he believes are, supporting domestic terrorism. Again, I don't, if we're just talking about domestic terrorism, regardless of the fact whether there's any merit to such allegations, um, to me, 501p only applies to foreign terrorism. But regardless, that has certainly gotten some people's attention and some concerns. But beyond 501p, again, things have happened in the last 8 months, 8.5 months that have surprised me to no end from a legal perspective. But from my vantage point, the only other way that the IRS can revoke the tax exempt status of a tax exempt organization is to go through the IRS audit process. And I sent an article over to the GWS CPA team and Maria that I wrote maybe 3 months ago called like how the IRS can and cannot revoke a nonprofit's tax exempt status that talks about all of these issues and basically all of the rights that a tax-exempt organization has to defend itself in the event that its tax-exempt status gets challenged. The all the rights in an examination, all the rights in the IRS appeal process, and then the rights to challenge that in court. I've been through about 75 IRS audits and appeals of tax-exempt organizations. There's a lot of opportunity to defend and protect yourself. A lot of the allegations that we've seen some folks in the administration make about the tax exempt status of Harvard University and others needing to be revoked. Never mind the fact that it's a crime for the president or the vice president to call for the an IRS audit of a tax exempt organization. Um, but regardless, even setting that aside, to me, there would be some real hurdles in some of the allegations that we've heard about certain tax exempt organizations in terms of their ability to have their exempt status revoked. And keep in mind, during that entire time, which can take years, all of it has to remain private. The IRS is not allowed to disclose that. All of this to say that while there is this 1980s U.S. Supreme Court decision called Bob Jones University that says that a tax exempt organization that is acting contrary to well-established public policy can have its tax exempt status revoked. You still have to go through the whole IRS appeals and IRS examination and audit process. And I think it would be a real uphill climb. So all of that to say, I don't think this is a really serious threat for most tax exempt organizations. I don't think you should be losing a lot of sleep over it. I've had clients come to us and say, should we be planning and doing certain things? Should we be, thinking about creating some new alternative organization, moving assets there, other things like that. And to me, I'm just not seeing the significant risk there, at least as of yet. We'll have to see how this plays out. Someone asks, in the unlikely event that a nonprofit organization loses its C3 status, what happens? Yeah, this is important, and I wrote about this in the article that Megan posted in the chat. Um, if a tax-exempt organization ultimately loses its exempt status, when you get audited for usually 3-year period because there's a 3-year statute of limitations generally, and typically and it's based on when the Form 990 was filed. Basically, the IRS has 3 years to initiate an examination from the time that the 990 was filed, and they typically will audit 3 years. If in the end you get revoked, the IRS can retroactively revoke you for those 3 years. They can assess federal corporate income tax on any net income you had for those 3 years, and as well as interest. and then that's it. It doesn't mean your organization goes away. Okay, the IRS has no ability to force a dissolution of an organization. Only a state attorney general can do that, and that rarely happens. Even in the NRA case, the New York AG, and I was her lead expert witness in that case. She tried to get the NRAs dissolved, and the court said no, we're not going to allow that to happen. And so, even in a case like that, it rarely happens. The IRS certainly has no ability to dissolve an organization, to make it go away, to take its assets. It can't. If a tax-exempt organization gets revoked after it pays whatever, if any, income taxes it owes for its net income for those 3 years, it remains a taxable nonprofit organization. And it has every right to go back to the IRS and maybe change whatever things led to the revocation and then reapply for recognition of its tax-exempt status. And so all of those things are really important to keep in mind. And I would encourage nonprofits not to be hasty and take rash actions here in response to, what are some pretty serious threats that are being voiced, by the president and vice president of the United States. But I don't see them as really serious threats for most nonprofit organizations.
Thank you. So since you're talking about revocation of status, this is my question. I wanted to just get your thoughts on the Nonprofit Governance Integrity Act, which is introduced in the Senate, which would potentially revoke status for any C3 or C6 that has a Chinese, Russian, North Korean, or Iranian board member, because we have a lot of members who are either international charities or large associations, and what you think could come from that.
Yeah, again, I'm not going to sit here and handicap whether a bill is going to pass Congress. And something like that, certainly has to overcome the 60 vote filibuster margin in the Senate. And so like most legislation that's subject to the filibuster, um, like probably unlikely. But look, we've seen other legislation in the past pass that affects tax-exempt organizations, usually in response to, what are perceived as abuses or a problem or something like that. Sometimes legislation that's not super well thought out. I'm not suggesting that this bill, which I've read about, is bad or good. I don't really have an opinion on it. I generally don't like kind of the IRS meddling in the governance of nonprofit organizations. I generally think it's kind of outside of the IRS's wheelhouse. Um, it really doesn't have the expertise to be doing that. And this seems like kind of hasty and really unusual legislation. I can't really think of other areas, maybe except involving 501(c)(3) credit counseling agencies, where the IRS gets into regulating the governance of a tax-exempt organization. Um, but whether it's going to pass, I have no idea. And if it does, then we have to deal with it. And I can already think of some even clients of ours that it would have some repercussions.
Yeah. Okay, so given everything that's going on procedurally, is there any way to override a Supreme Court decision other than congressional legislative action?
Well, it all depends on what the decision is based on. If it's some of the Supreme Court's decisions are based on constitutional principles, on the Constitution, saying that some act is unconstitutional, for instance. And if that's the case, if Congress, for instance, says that if the Supreme Court says that a law that Congress passes is unconstitutional, Congress can't deal with it by just enacting a new law. It can modify the law in a way that would maybe survive Supreme Court scrutiny and not be unconstitutional. It just all depends on what the issue is. Like sometimes the Supreme Court will say that an action that a federal agency took did not comply with the law. Like the Administrative Procedures Act or other things like that. And that can be cured by the administration complying with the Administrative Procedures Act and things like that if it wants to issue certain regulations or take certain actions. And certainly Congress can generally do almost anything that the administration could do by statute. So it's a complicated answer, and it's really dependent on the specific circumstances.
Okay, thank you. I mean, that's it right now for questions. People, if you have questions, put them in the chat. My question, I guess, to you, Jeff, would be given these areas of risk, where are you getting the most questions right now? Where are your clients having the most activity and trying to kind of address these issues?
So it's always hard to generalize. We're generally billing time to about 200 clients a month, and it's a pretty wide array of associations and 501(c)(3) nonprofits, C4s, all different types of organizations. Um, I get this question a lot. What are the issues that you're dealing with the most for your clients? And I will say that most of the issues we deal with are not these hot button, big threats, sexy issues that everyone's been talking about and writing about and reading about. They're the day-to-day stuff that, kind of the more run-of-the-mill stuff that might not be as interesting and exciting, but really important. Contract reviews, dealing with bylaw issues, hotel and convention center contracts, dealing with all sorts of employment issues, copyright and trademark, licensing issues, infringement issues, protection issues, antitrust issues for trade and professional associations, dealing with the regulation of lobbying and political campaign activity. Talked a bit about that, dealing with nonprofit fundraising regulation, gift agreements, gift acceptance policies, dealing with issues involving subsidiaries, affiliates, chapters. We're dealing with right now actually a lot of M&A activity in the nonprofit space, mergers and acquisitions. Probably have about 12, 13 different deals going on, all different sorts. Classic mergers, acquisitions of smaller organizations, acquisitions of assets, two organizations coming together and doing essentially joint ventures, or like all sorts of things like that. We also are actually doing far more internal investigations than we've ever done before. We've probably done at least 10, 12 in the last year and a half or so, a couple going on right now, dealing with a lot of governmental investigations. That is new and different. I think one Senate, one Senate committee, two House committee investigations, and two federal agency investigations, all of which are largely politically driven. But they don't go away, and they can be pain in the neck to deal with and expensive and sometimes public. Um, but then something, two areas that are new and different that we are spending a good amount of time with our clients on. One is doing, what we refer to as DEI reviews. We're probably up to almost 40 different reviews, several going on right now, of nonprofit organizations looking at their various DEI related policies, programs, initiatives, activities, and giving them guidance as to how to mitigate their legal risk. And I talked earlier about those three areas of legal risk in the DEI space: federal funds, employment, and grants, scholarships, or fellowships, as well as non-legal risk. And frankly, for most nonprofits, their biggest risk in the DEI space is non-legal. It's business, it's financial, it's reputational, it's targeting risk. And we are seeing scores of organizations being told by members, by conference attendees, by sponsors, by exhibitors, by advertisers, by donors, grantors, that we don't like your DEI activities. We don't like your DEI track at your conference. We don't like your, you name it. And then threatening to, or even in some cases, not renewing their membership, threatening to boycott conferences, threatening to pull their funding because of this. And so it's a big area. We're seeing a lot of federal employees say they're not allowed to attend any conferences that have any DEI content. And so this has been definitely an area that my colleagues Kevin and Holly and I have spent a lot of time with dozens of nonprofit organizations. And I'd say the last um, newer area that we're providing a lot of advice and counsel is in the AI space. Um, Not whether or how nonprofits should use AI, because virtually every nonprofit is. It's not a question of whether, it's a question of how are you going to, from a legal perspective, how are you going to regulate it? What guardrails are you going to put on your employees and your volunteer leaders and others? So we're working on quite a number of kind of nonprofit AI usage policies, both for employees as well as volunteer leaders, which are really important. And they continue to evolve, by the way. And yeah, someone asked my colleague Holly yesterday, for like a model template, like AI usage policy. And I saw her response and she said, I mean, we have ones that we've done and we can, certainly make them, turn them into model policies. But she said, every nonprofit is different in terms of how it uses AI, in terms of its risk tolerance, in terms of whether it has like an enterprise-wide, like AI platform that its employees are required to use, as opposed to just doing things on their own. So it's really different, and it's kind of like a privacy policy. It has to be tailored to each organization depending on how you are using AI. But it's really important to be thoughtful about how you are going to regulate the use of AI. So, for instance, one policy that I just edited and sent off to a client last week um, says that, generally speaking, no confidential or proprietary information of the organization can be inputted into an AI platform. However, it does provide exceptions if A, like a supervisor signs off on it, and B, if the AI platform has the sharing feature turned off, namely where the platform is not able to use that input that's put in by the nonprofit staff or whatever to train itself. So basically, anything that gets put in just stays self-contained. And there's a lot of nonprofits have kind of developed their own proprietary AI platforms that allow the inputs to train the platform, the AI platform for that nonprofit, but that never leaves the nonprofit. It stays self-contained. And that's a really important distinction and feature because there's a lot of, as you all know, there's a lot of incredible things that AI can do with that confidential or proprietary information, but you certainly can't risk it ever getting out there outside the organization. So things like that are an area that we are certainly spending a lot of time on, dealing with trying to regulate speakers and authors, and do they have to disclose if they used AI? Do they have to represent and warrant that if they did use AI to, write an article or write a speech that, they've done their own vetting and independent verification and things like that. These are all important things that you need to keep in mind.
Yeah, that's complicated, especially when you're planning conferences with lots of different people participating. Um, okay, I'll give one last call for questions, and you did cover quite a few things that are kind of emerging issues. I bet you've had a busy year, Jeff.
We have had our busiest year yet. We are extremely busy, but and not complaining. When you're in private practice, that's not a bad thing.
Right. Is there anything else that you kind of see on the horizon? I know you talked about the stuff that's coming up and busy for you now with the DEI reviews and the AI stuff. Is there anything else you can think of that people should be kind of keeping an eye out for in order to kind of guard themselves against risk that might be coming down the pike related to what's going on?
Certainly, not everything we deal with is risk related. Think about, mergers and things like that. That doesn't have to do with risk. It has to do with taking advantage of good opportunities, strengthening your organization. So, you know, uh, I, it's not, again, not to, repeat myself, but it's not, there's really I've been doing this for 30 years, and there are very few times when there's a lot of new developments in the law. Certainly what we're seeing in the DEI area, what we're seeing in the AI area, these are certainly new developments. We saw the tax bill, the big beautiful bill. There was a lot of threats of various provisions being put in there that had been promoted by the Tax Foundation and others that could have been significant threats to tax-exempt organizations. Most of those did not materialize. Um, I don't know that any of them really will materialize. There were times in the past, like I remember in the 90s when I was first getting started practicing law, there was so much legislation that was passed that affected tax-exempt organizations. There was a lobbying tax law for C6 organizations. There was a lobbying disclosure act, the Federal Lobbying Disclosure Act. There was the corporate sponsorship legislation. There was the Volunteer Protection Act. And those are four really big bills that affected tax-exempt organizations. We don't see that much of that. There was also the big Sierra Club decision involving tax-exempt royalties, the exception from UBIT in the 90s. So there was just a lot of activity there. We generally don't see a lot of that. It's the same old issues that we deal with all of the time. I will say one other area that we're seeing, I don't know if it's just happening more or if just more of it is coming to our firm, and some of this involves internal investigations, is that we're seeing more and more, how do I put it, bad conduct by board members. We're seeing it so often, whether it's sometimes it's at conferences and events, often involving alcohol, often involving bad conduct that occurs around the hotel bar later at night after a lot of drinking. But some of it just involves anything else. And whether sometimes officers, directors, other volunteer leaders, we are seeing more and more bad conduct by board members that sometimes creates employment liability risk for the organizations. Sometimes we just completed an internal investigation. I gave a report to the board of directors on Saturday involving allegations about the founder and current board member of an organization who, is basically verbally abusing staff and others and micromanaging and just creating all sorts of issues. And it was actually the CEO who lodged the complaint against this individual. And it was actually quite challenging for us to convince some of the board members to enable us to go ahead with an internal investigation. They finally agreed to let us do so. And then again, we presented our findings and recommendations to the board. But we're seeing more and more of this. And we had quite a few very substantive recommendations to make to them, most of which, to their credit, the board adopted. But we're just seeing more and more of this. And some of it you can deal with proactively through good board trainings. Like I do a lot of board training sessions on this, but some of it you just can't train for some of this and you can't prevent some of it. You just have to deal with it proactively and aggressively and very thoughtfully. But that is an area that we're seeing more and more problematic conduct, and it is a bit disconcerting.
Yeah, I mean, that's disappointing to hear. Oh, okay. I did have one last question pop up. Is it a good idea to review the D&O insurance coverage in the code of conduct then?
Yeah, great question. So let me deal with the latter first. So first, let me distinguish a code of conduct versus a code of ethics. And by the way, I should have stated, and Megan, if you can put this link into the um, into the chat or just a link to our website, tenenbaumlegal.com. If you go to the resources tab at tenenbaumlegal.com, you'll see a sub-tab for publications and you'll see one for recordings. We have a ton of articles there in the publications tab, probably 150 articles, I would guess, and presentations on different nonprofit legal topics. Then we have a ton of recorded webinars on all sorts of issues, and we're constantly adding new things there. There are articles and presentations there on many of the topics we've talked about, including a really good presentation from my law partner, Nisha, about codes of ethics and codes of conduct. There's also a great new article by Holly on internal investigations that I think is fantastic. She also wrote a couple articles about AI legal issues, and there's a lot of good stuff there that I would commend for your reading. But a code of ethics generally refers to, it's not a legal term, but it generally refers to a code, we often see it in professional associations, that regulates member conduct in their profession. There are two different types, an enforceable code or an aspirational code. Whereas a code of conduct, again, it's not a legal definition, but a code of conduct generally means a code that regulates members and non-members conduct in their engaging in kind of the nonprofits activities, conferences, events, both virtual, in person, including like board members and volunteer leaders and all of that. Generally, all wrapped up into a code of conduct saying, generally prohibiting certain types of bad behavior, spelling out that those will not be accepted, and then providing for a whole range of sanctions, everything from censure all the way up to, banning people from attending certain in-person and/or virtual events to even expulsion as a member of a membership association and things like that. And sadly, we've had to deal with all of these things, and the attorneys often get involved, usually do get involved in these things. But having a good, strong code of conduct, publicizing it, making sure people are aware of that is really important. And then taking prompt corrective action when you get allegations of violations of that code are really, really important. And then sometimes, like we've dealt with a lot, even this year, I can think of probably 6 or 8 cases we've had where, the organization is taking some adverse action against, say, a member for violations of the code of conduct, and then they threaten litigation, they threaten defamation claims, other things like that. Um, in all of those cases, none of that ever turned to litigation, but there's always a lot of threats of it, and it gets people concerned, which is a good lead into the other part of the question, which is D&O insurance. Um, Directors and officers liability insurance is really important. We regularly review our clients' insurance policies, myself in particular. One thing I'll say is D&O insurance is important, but it's not the only insurance that's important. Um, it's part of your whole insurance package. The most important insurance policies for most nonprofits are going to be directors and officers liability insurance, commercial general liability insurance, property insurance, cyber insurance, and then what is either sometimes called errors and omissions insurance, sometimes it's called professional liability, sometimes it's called media liability. But it's really important for you to work with a good, experienced insurance broker or agent. And I know there are a number that are members of GWS CPA because I see them all the time at your symposia and other events, that really understand the nonprofit space, can look at your nonprofits or your clients' activities, programs, and determine and work with your legal counsel, of course, to determine where are our potential risks, and then trying to make sure that you have coverage that can cover those risks and minimize your coverage gaps. You can't insure for everything. For instance, you cannot insure for breach of contract, except employment contracts, but you can insure for a lot. And with both D&O and E&O insurance, there are no standard forms like there are for commercial general liability and property. They're all different, and some are a lot better than others. And then, of course, depending on your activities, like for instance, if you do a lot of publishing of like journals or magazines or things like that, your D&O insurance is probably going to have an endorsement that excludes coverage for publication related liability like defamation and copyright infringement. And so you're going to want to make sure you have an errors and omissions policy that will cover liabilities from that. Similarly, if you have certification and accreditation programs where you engage in standard setting, the D&O insurance is probably going to have an endorsement that excludes coverage for that. So you need an E&O policy to do that. D&O policies also do not cover claims for bodily injury or property damage. So if you're engaging in activities that create those sort of risks, again, you need an E&O policy to cover those sorts of risks. And remember that the term D&O is a bit of a misnomer because, yes, it covers directors and officers. Some of the policies cover other volunteer leaders and committee members. They certainly cover employees, but most importantly, they cover the organization itself. And that's where D&O claims, the vast majority, are filed by the organization itself to protect it. But keep in mind, it's all part of that whole package. Another form of insurance that some nonprofits have is event cancellation insurance, although it's gotten a lot more expensive since COVID. But you want to have a full, complete package. And don't just focus on the dollar amounts of your limits of liability. Of course, those are important. As part of the board trainings I do, one of the things I'm always looking at is your insurance coverage. And, I see sometimes a nonprofit has only like $1 million limit of liability and they're like a $25-30 million organization. That's probably on the low side. That's always important to look at, do your cost benefit analysis, see what it's going to cost you to get maybe $2 or $3 million in coverage. But don't just focus on the limit of liability. You got to look at what minimizing coverage gaps, because it doesn't matter what your limit of liability is. If a claim's not going to be covered, it doesn't do you any good. And so, work proactively when it comes time for your policy renewal with your broker and with your attorney to make sure you try to do everything possible to minimize those coverage gaps.
Yeah, really important. Okay, well, with that, I'm going to have to wrap us up. Thank you, Jeff, once again for coming to speak to us. We always love having you here, and we're going to see you again soon. You're going to be doing your Ask the Nonprofit Attorney session at the symposium this year on December 9th, Tuesday afternoon. Hopefully we'll stay for the reception after.
Absolutely.
And thanks a lot for your time today. Everybody else, stay on the call. We're going to take like a 5-minute break. If you want to stay for symposium planning, we'll come back in about 5 minutes.
Thanks, everyone. Take care.
Thanks, Jeff.